Hey everybody, News Now Wyoming here. Why can't I get anything done? Why is it that I just keep getting so sidetracked? Right now I was working, about to start, not putting together all of the list of First Circuit, Second Circuit, etc. For malicious prosecution when I came across this guy. And it barely touches on malicious prosecution, so it's way off topic. Why would I cover it? Because it is an interesting case law. Again, this is only for the First Circuit. It is not nationwide. First Circuit looks like is Maine, New Hampshire, Massachusetts, Rhode Island, and then any territories. Not exactly sure what all. Looks like Puerto Rico is the only territory. Okay, that is covered under the First Circuit, and that's actually where this takes place at. Interesting case. I couldn't resist doing a quick video on it. It's 78 pages long on this decision, so I'm not going to read everything. But oh my God, let's just dig into this. When, and it answers an important question. When is it acceptable for a cop to lie to a potential suspect? Great question, because we hear that all the time. Cops are allowed to lie to you. Cops are allowed to lie to you. They don't have to tell you the truth. They can lie to you about whatever they want. Well, no, there are limitations on it. So this case, and you guys, this was decided in 2019. And I will say that I don't agree with the crimes that this guy was accused of doing. Obviously, I wish that the cops would have done things correctly and received a search warrant instead of bypassing it, as we'll see, because this guy for pictures of children is what he was busted for. And God, I wish that the cops wouldn't have screwed it up, because those are the people we want off the streets. Those are the real criminals. Alright, so this case requires us to consider the constitutional boundaries for the use of deception by law enforcement officers seeking consent for a warrantless search. We conclude that the search at issue here violated the Fourth Amendment because of circumstances including a lie that conveyed the need for urgent action to address a pressing threat to person or property, vitiated the consent given by appellants. We further hold that the defendants are not entitled to qualified immunity from civil liability for the unlawful search because any reasonable officer would have recognized that the circumstances were impermissibly coercive. However, we reject a related claim alleging malicious prosecution on the ground that even if it had merit, the defendants would be entitled to qualified immunity. We therefore vacate in part and affirm in part the District Court's grant of defendant's motion to dismiss plaintiff's complaint. So, appellant Pagan-Gonzalez claims that his Fourth Amendment rights were violated when federal agents unlawfully searched his computer and when they subsequently arrested and detained him on child pictures charges based solely on the evidence obtained in the unlawful search. After the criminal charges were dropped, Pagan-Gonzalez brought the suit for damages pursuant to Bivens. In Part A, we recount the largely undisputed facts of the underlying event, setting forth the complaint's well-pleaded facts in the light most favorable to the plaintiff, which is the standard for motion to dismiss, right? The non-moving party gets the light most favorable. In describing the objectives and conduct of the defendant law enforcement officers, we also rely on an affidavit submitted by one of the agents in support of the criminal complaint against Pagan-Gonzalez. Part B, we describe the Bivens action and the District Court's rationales for dismissing it. So the challenged conduct and criminal process. So here is where we're really going to cover what exactly happened. In 2013, approximately 10 federal agents appeared at the door of the home shared by Pagan-Gonzalez and his parents in Cabo Rojo, Puerto Rico. Special Agent Anna Moreno, one of two officers named as defendants, identified herself as an FBI agent and reported that the law enforcement officers were there because a modem in a computer at the house was sending a signal or viruses to computers in Washington. In fact, an FBI agent had downloaded child pornography from a computer that agents believed was located at that address, and the agents had come to the home to investigate. The agents asked the family for consent to inspect their computers and said they would try to fix the modem that was sending transmissions to Washington. The agents explained that if they could not make the repair, they would take the faulty computer and provide a replacement at the FBI's expense. Pagan-Gonzalez, age 21, and his parents signed consent forms authorizing the computer searches. After inspecting 2 computers, the agents told the family they needed to take Pagan-Gonzalez's laptop. Pagan-Gonzalez's father protested because his son, a college student, needed the computer for his classes. But the agents told the family they could no longer touch or access the laptop because it contained evidence of a crime. The family was not told that the agents had determined the laptop contained possible child pornography in the form of graphics, videos, or search terms, as Agent Bonella later reported in the affidavit for the criminal complaint. The computer search from Pagan-Gonzalez was further examined by the FBI's analysis team. The laptop contained numerous images and videos of minors engaged in horrible stuff, and also revealed that Pagan-Gonzalez had both received from others and shared child pictures. Agent Bonella thus prepared the criminal complaint alleging that Pagan-Gonzalez had transported and received child pornography. Oops. There go. Well, I'm not monetized anyway, so as long as they don't remove my channel, I don't care. On December 11th, 2013, a magistrate judge issued a warrant for his arrest. Early the next morning, Pagan-Gonzalez and his parents were awakened when armed federal agents burst into their home to arrest Pagan-Gonzalez. You guys, this is one thing I will always have a problem with. Why does it have to be early? You probably know when he goes to school. You probably know when he's home. When he's not home. Typical times. What in here showed that he was an actual dangerous suspect where you had to do a early the next morning? It doesn't say how early, but let's imagine a 3 a.m. burst through the door call. Warrant. Arrest warrant. Nothing in here suggests that that is acceptable. Nothing. So yes, that does piss me off. No matter what he's done, just ridiculous behavior on the part of the cops. He remained in custody until his parents were able to post bond a week later. So that he was indicted. He filed a motion to suppress the evidence obtained from the search of his computer, arguing that the agents' misrepresentations about their investigative purpose limited or vitiated the consent given by the family for examination of their computers. He asserted that the deception rendered the search unreasonable and illegal and hence a violation of his Fourth Amendment rights. Instead of responding to the suppression motion, the government filed a motion to dismiss the case in the interest of justice. So, illegal search, and so they just dismissed the case. Not a favorable outcome. Okay. Exactly 1 year, he and his parents filed a civil lawsuit. He alleged that he consented to the officer's entry and search only because the agent stated that they were looking for the source of the signal or viruses that had been detected in Washington. They were tainted by defendant's lie about the true reason of why they were there, and blah blah blah, right? They moved to dismiss for failure to state a claim. Entry to plaintiff's home and search of their computer was lawful, and the agents were in any event protected from liability by qualified immunity. So the district court dismissed the complaint in its entirety. Accordingly, so the district court ruled at the time of the 1 year allegation on this one, I guess, it's got a 1 year statute of limitation, was from when his home was searched. So that's when it started behaving, or counting. 1 year limitations period. The court treated as timely his claim based on his arrest and the subsequent criminal process, but dismissed that claim as well because the complaint is devoid of any allegations that would support a finding of lack of probable cause. It was appalled by the allegations that FBI agents would ask to enter his home without a warrant and through a ruse, obtain consent from all family members to search and seize his laptop. And I can't remember what TV show it was. I do remember watching a TV show where might have even been a Law and Order SVU, Elliot, whatever show. Might have been one of those where the cop lies to the suspect who's on his on the hospital bed, saying that he's dying and he's a fake priest and getting a confession. That's the type of stuff that I'm thinking of right here. And yes, that case in those facts would have been thrown out under the same issues under at least the First Circuit, which New York is not part of. New York is part of the Second Circuit. Nonetheless, it found meritless plaintiff's contention that any evidence obtained in violation of his constitutional rights would negate the probable cause found in this case. The exclusionary rule does not apply in civil cases. The court cited precedent holding that in the context of a civil malicious prosecution claim, the reliance on unlawfully obtained evidence does not nullify the officer's probable cause to arrest. That's a stupid argument. And again, all of these arguments about malicious prosecution, I don't understand. I don't get them. I don't understand the court's position on it. I guess I will never understand it. I can read about them. I can read all the court cases in the world. I just don't understand it. I don't get how you ever reach that level of malicious prosecution. So anyway, back to this case. Pagan-Gonzalez challenges the district court's holdings of the statute of limitations, the viability of his malicious prosecution claim, and the agent's entitlement to qualified immunity. Specifically, he asserts that the Fourth Amendment claim based on the officer's entry to his home and search of his computer was timely because it did not accrue until the day of his arrest. As for deficiencies in the actual factual allegations, he maintains that he should have been allowed to conduct discovery to ascertain the specific participation of each agent in the challenged conduct. He also argues that the malicious prosecution claim should proceed because initiating and prosecuting criminal charges premised solely on illegally seized evidence violates the Constitution, and a reasonable officer would have understood as much. And I agree with that. I cannot disagree with that. So the statute of limitation. Oh, so this state law determines the statute of limitations for a federal civil rights cause of action. I did not know that, you guys. So that's why it's 1 year here and 3 years here in the 10th Circuit, or at least in Colorado. It is undisputed that Puerto Rico's 1 year limitations period for personal injury actions apply here. The accrual date for such claim, however, is governed by federal law. Under federal law, the statute of limitations on a Bevins claim begins to run when the plaintiff knows or has reason to know of the existence and cause of the injury which is the basis of his action. So he argues that the district court erred in finding that the entry and search claim accrued when the officers took those actions. We agree. On the day of the search, he and his parents were told that the agents needed to enter their home and inspect their computers to address a virus or signal that was detected by authorities. They neither knew that day nor had reason to know that the agents had misrepresented their purpose and elicited consent to search based on falsehood. Although they were told that evidence of a crime had been found on his laptop, they could not have known that the evidence related to a crime committed by Pagan-Gonzalez or to a matter other than the one the agents had identified as the reason they needed to search. Hence, only when the agents returned on December 12th to arrest him did he and his parents know the existence and cause of the injury of the basis of the legal actions. So that's a good legal argument. I can't disagree with that. The merits and qualified immunity. The defendants argue that dismissal of the search-related claim should be upheld on the alternative ground that the ruse used by the officers was constitutionally permissible. And they say, at the very least, the defendants are shielded from civil liability by qualified immunity. Both of these rationales are, in fact, components of the qualified immunity analysis. Officers are entitled to qualified immunity under 1983 unless they violated a federal statutory or constitutional right and the unlawfulness of their conduct was clearly established at the time. Excuse me. Because we conclude the officer's deception invalidated the consent given for their warrantless entry and search, thus rendering their actions unlawful, we must also consider the second prong of the inquiry, whether the defendants are nonetheless entitled, because no reasonable officer would have understood that her conduct violated the Fourth Amendment. So the consent exception. Sanctity of the home is at the core of the Fourth Amendment's protection against unreasonable government intrusions. And we've talked about that in multiple cases, right? The protection of your home is, the sanctity of your home is paramount to your rights. That is extremely important. The Supreme Court has thus consistently held that the entry into a home to conduct a search or make an arrest is unreasonable under the Fourth Amendment unless done pursuant to a warrant. Carves out an exception to the warrant for consensual searches. A validly obtained and voluntarily consent renders a search or seizure reasonable, thus eliminating the need for a warrant. That makes sense. As a jealously and carefully drawn exception to the warrant exception, the government thus fittingly bears the burden to prove valid and voluntary consent. Courts evaluate voluntariness in the context with the same close scrutiny of the circumstances prescribed by the Supreme Court for assessing the voluntariness of a confession. The totality of the circumstances review must take into account, where appropriate, any evidence that law enforcement officers' fraud, deceit, trickery, misrepresentations prompted defendants' acquiescence to the search. So, deceit can be relevant to voluntariness. Thus, to find the lawful search as the government urges, we must conclude the consent to enter and search given by him and his parents was validly obtained and voluntary, notwithstanding the agent's deception concerning the purposes. Before evaluating the particular facts here, we describe the existing case law. Okay, we're going to skip this. And in fact, you guys, we'll be right back. Okay, so we are trying to skip down beyond the case law. So, notwithstanding the need in each case to consider the totality of the circumstances, there is consensus in the precedents that two types of deception have an impermissibly coercive effect. First, the Supreme Court has soundly rejected the consent to search obtained by officers who falsely claim they have a warrant. That situation, the court explained, is instinct with coercion because the officer announces in effect that the occupant has no right to resist the search. It is thus well established in our own law and elsewhere that deception invalidates consent when police claim authority they lack. Second, relying on equivalent reasoning, courts have regularly held that coercion is implicit when officers falsely present the need for urgent action. When an officer lies about the existence of exigent circumstances, he also suggests that the occupant has no right to resist and may face immediate danger if he tries. Where agents falsely implied that a bomb was planted in the apartment they sought to search. Oh, we're still talking about precedents here. While the fact-specific nature of the voluntariness inquiry makes it difficult to draw many bright lines within this murky area of law concerning consents obtained by deception as to purpose, courts have uniformly recognized that the Fourth Amendment may be violated when consent is obtained through a law enforcement officer's false claim of authority or lies conveying an exigent need for the search. In such instances, the deception may be sufficient on its own to vitiate the voluntariness of the resulting consent. So an officer may not use a ruse that, if it were true, would give the suspect no real choice but to consent. Against the backdrop of the law described above and mindful of the demanding scrutiny required by big word court in assessing consent, and that's a First Circuit decision in 1989, we have little difficulty concluding that the entry and search as alleged in Pagan-Gonzalez's complaint violated the Fourth Amendment. Roughly 10 FBI agents appeared at appellant's door with the alarming news that computers in Washington, D.C., the heart of the country's political and military operations, were receiving signals or viruses from a computer at the appellant's location. If the report of a virus infecting technology in the nation's capital was not itself enough to convey an urgent need to address a pressing threat, the show of force by the federal office agents elevated the seriousness of the situation, communicated the problematic computer posed a substantial threat, perhaps even to the nation's security. Whew. So 10 FBI agents showed up. That's a show of force. To be sure, the fabricated emergency was not one that presented an immediate threat to the personal safety of Pagan-Gonzalez. However, we reject the government's suggestion that a finding of coercion based on fabricated exigent circumstances is limited to lies about an imminent physical danger or a time-critical investigation involving the well-being of a vulnerable person. There is nothing fanciful about the havoc that can be wreaked by a computer attack on the federal government. By late 2013, when the conduct at issue here occurred, cybersecurity was a major concern within the FBI itself, and the serious threat posed by counter cyber attacks was also public knowledge. In March 2012, for example, the FBI's then top official on cybercrime stated that terrorist groups were increasingly seeking to use the network to challenge the United States by looking at critical infrastructure to disrupt or harm the viability of our way of life. Severity of the purported threat in this instance was made plain by the number of agents dispatched to address it. Both of these factors, the claimed threat and the significant show of force, are consequential in assessing the voluntariness of his consent to enter and search. Nor do other factors diminish the coerciveness of these aspects of the encounter. His education and family might have enabled him to resist some types of official deception, but not the sort of fabricated emergency created by the officers in this case. This was not a situation in which government agents were merely offering help to a private citizen. Unlike in Spivey, where the officers were responding to the defendant's request for help, or Parson, where the officers were purporting to protect the defendant from identity theft, the agents here relied on the predictable acquiescence of citizens to assist law enforcement when pressed to do so, in a situation where it reasonably could be inferred that national interests were at stake. In short, the totality of the circumstances, as alleged, point strongly to a situation involving an unwitting, trusting beguilement. So here they're going to decide against qualified immunity. We're going to skip that. Malicious prosecution. He has a viable Fourth Amendment claim for malicious prosecution. Remember, we learned in yesterday's video that malicious prosecution is normally a 14th Amendment violation. Rarely does it fall into the Fourth Amendment. Or no court that I can find so far has found that it violates your Fourth Amendment claim. To succeed on a malicious prosecution claim, our case law states that the plaintiff must establish that the defendant caused a seizure of plaintiff pursuant to legal process unsupported by probable cause and criminal proceedings terminated in the plaintiff's favor. Pagan-Gonzalez contends that his claim meets each of these requirements because the government voluntarily dismissed the criminal proceedings against him, thus, in his view, terminating the prosecution in his favor and excluding the unlawfully obtained evidence. His arrest and prosecution were unsupported by probable cause. The government counters that Pagan-Gonzalez fails on multiple grounds to state a constitutional claim of malicious prosecution. First and foremost, it challenges his assertion that evidence obtained from an unlawful search may not be used to support a finding of probable cause for an arrest, detention, and prosecution. Citing published decisions from other circuits and unpublished decisions of our own court, the government points out that the exclusionary rule has been held to apply only in criminal proceedings. The widespread view that probable cause to arrest or prosecute may be established in criminal proceedings with unlawfully seized evidence means that regardless of our view on the merits of Pagan-Gonzalez's malicious prosecution claim, the defendants are entitled to qualified immunity on that claim. So they're not going to rule on if they agree with their reading of favorable, but because all the other courts have ruled against it, they're not on notice that what they did was malicious prosecution. No clearly established law barred the defendants from using evidence obtained in the unlawful search to support probable cause for the criminal charges brought against them. And so, concluding, we do not reach the first question of the qualified immunity analysis, and they don't have to reach the first one. So, for the reasons given above, we vacate the dismissal of his search based on the Fourth Amendment claim, and they remand down. So, there you guys go. Concurring opinion follows. And there we go. What do you think? What do you think about the limits on when cops are allowed to lie to you? What do you think the limits should be? I will agree that there are times, if they are undercover, they should be able to lie that they're not a cop. I mean, that sounds reasonable. But what do you think the limits should be on it? What do you think of the case here? Should the case have been dismissed in the first place, or does the end justify the means? What are your thoughts? Let me know in the comments below. Have a great day.